consider coming to Veg Fest on June 4th at Eastern Market. Consider becoming a member of Veg Michigan, and consider joining our e-newsletter if you're not on it already. And I just want to welcome all of you here. Some of you come to our virtual events regularly. Some of you might be new. So whoever you are, we're glad to have you. And with that, I want to get on with the program, and that's why we're all here. So I'd like to turn it over to Bea Friedlander, who is a longtime supporter and member of Veg Michigan. And she is also a founding member and president of the Board of Attorneys for Animals. So we're very happy to have you with us tonight, Bea. Thank you for helping to organize this evening's presentation. I also want to give a shout out to our board member, Val, from Traverse City, who helped to organize this event. So Val is on. Val, you can give a wave. Thank you so much for helping to organize this. And with that, I'm going to turn it over to Bea, who is going to introduce our wonderful speakers for this evening. And again, thank you all for being here.
Thank you, Kim. And tonight we're going to talk about a case in the Michigan Supreme Court, Michigan Farm Bureau versus Eagle. It has huge consequences for Michigan's environment, and basically it pits the regulators against the CAFOs. And the CAFOs want to continue unchecked polluting our waters. It's also, frankly, a bit difficult to understand. Fortunately, tonight's guests, Zach Welker and Jim Olson, are here to help guide us through the case, talk about its implications and what you can do. Both of them were involved in drafting an amicus brief to the Supreme Court that supports the position of the agency, Eagle, in continuing to regulate CAFOs. Zach is For the Love of Water Flow's legal director, and he partners with many groups, tribes, conservation organizations, frontline community justice organizations, and scientists to ensure the waters of the Great Lake Basin are healthy, public, and protected for all. Before joining Flow, Zach spent more than a decade in the Pacific Northwest on water, fisheries, and other natural resources issues. Jim Olson founded Flow, and he is a senior principal of the Traverse City law firm of Olson, Bisdock, and Howard. He's represented numerous citizens and communities on matters involving water, public trust, environment, land use, takings, hazardous, and toxic tort law for over 50 years. He's written books, articles, and lectured widely, and he has a new course. He's even got a few films to his credit. My area of interest is animal law, but I have a lot to learn from these environmental law experts. And I believe that our arguments are stronger and people, animals, and the environment are more protected when we join together to tackle these difficult questions. So with that, I turn it over to our speakers, and thank you for joining us.
Thank you, Bea, and thanks to Veg Michigan for having us here tonight. I'm excited to get into this, and we have a lot of good information to share with you tonight. So I think Jim is going to navigate we put together a PowerPoint to hopefully make things a little bit more interesting for all of you. I do want to say what a pleasure it is to get to do this presentation with Jim. I mean, it's not every day you get to enter the brain trust of someone who's been in the same state for 50 years practicing law, and he knows everything about environmental law that there is to know in Michigan. And so it's great that he's offering up his time in retirement to share some strategies for how to obtain hopefully some solutions to the CAFO pollution problem. So thanks, Jim, for being here. I don't know if you want to say anything at the outset.
Well, only that doing things for 50 years, you do gather a lot of anecdotal and stuff in your memory bank, and hopefully I'll be able to share some of that this evening. But looking forward to our discussion afterwards too.
Thanks, Jim. Could you advance it, please? And it sounds like, the recording's back in progress. Okay, so I don't feel like it's probably necessary to convince anyone that on this call anyway, that CAFOs are a problem. CAFOs, again, are concentrated animal feeding operations, sometimes called confined animal feeding operations, but basically they just describe these terribly conceived facilities that house massive amounts of animals in inhumane conditions and generate a lot of meat down the road, and in the process generate a lot of waste. And I went through our amicus brief and picked out a few of the factual pieces of evidence that we included that continue to shock me. The second one I think is just amazing, that we're talking about in Michigan alone, 3.9 billion gallons of liquid waste and 1.3 million tons of dry waste are generated by CAFOs each year. It's just an incredible amount of waste. And then here, of course, too, we put down this comparison with many of Michigan's largest cities, seeing, just to give you some scale, so a single large CAFO produces 1.5 times more untreated waste than the human sanitary waste produced by all those cities, which I think is a pretty startling statistic as well. So we're dealing with just a massive amount of pollution and the problems it causes. So very briefly, all of that waste can cause E. coli contamination and make people very sick. The CAFO industry tries to dismiss this as just being akin to fertilizer, but within the wastes of CAFOs, you have significant amount of heavy metals, detergents, and pharmaceuticals. This causes every year in Lake Erie in recent memory, these massive algal blooms that turn the lake green and interfere with protected public trust uses like fishing and swimming and drinking. And a lot of this happens because the fields, basically the CAFO operators are looking for the cheapest way to get rid of their waste. And the cheapest way to do that is to spread it on their fields. And their fields don't need that waste because there's already enough nutrients in the soil as is. And so what happens is a lot of that waste just migrates down into this tile system that underlies the fields and is channeled off into Michigan's waters. And of course, this kills fish and causes all kinds of tourist harm and other economic harm as well. Next slide, please, Jim. Okay, so I think a little bit on how federal law treats CAFO waste. The Clean Water Act does not require CAFOs to be regulated as point sources. And so very briefly, if something comes out of a pipe, it's considered, or something similar to a pipe, it's considered a point source under the Federal Clean Water Act. And the act is set up that way because it's easier to track stuff if it comes out of a pipe. If it's a dispersed waste like happens in some agriculture, management of forest lands, things like that, it's harder to determine just how much waste comes off, and those are called non-point sources, and regulation of those sources are generally voluntary. And Michigan's fortunate in that I described that tile system that underlies the farm fields, and I think that helped precipitate Michigan's treatment of CAFOs as point sources, which is good news. The bad news is, unlike other point sources, and particularly those that deal with waste, there's no treatment of waste required under the general permit that CAFOs operate. So the permitting regime in Michigan is Michigan adopts what's called a general permit, and it contains basic terms and conditions and best practices that a CAFO is obligated to operate under. And as long as the CAFO agrees to operate under those, it receives a certificate of coverage under this general permit. So right now, the operative permit is one that was adopted in 2015, and the environmental community is worried because we still have these harmful algal blooms in Lake Erie that are caused by CAFO waste primarily, and lots of other negative and obvious environmental impacts. So anyone who's, got a head on their shoulders and isn't trying to deny regulation or regulatory power is aware that this 2015 general permit isn't doing its job. So the good news is that those get revised every 5 years. And in 2020, Eagle adopted a revised permit. And I think we can go to the next slide now, Jim.
Well,
thank you.
I just do this real quick. I threw this in there to the surprise of Zach, probably. I wanted to just stress that it's not only a water quality issue. These CAFOs are water use issues. You can see here that in Minnesota, 2.3 billion gallons of water just used in the watering of the animals. Part 31 that Zach has described, and will describe more, that the state uses for the general permit, does not regulate water quantity, just quality. Other laws do, but the farm community has structured that in a way where water use is easy for them to get because of relaxed computer standards. In addition to water use, you have the water used in the production of the crops that are fed to the animals, and you have the water that's used in the production of the biodigesters or biofuels. There we go. Sorry, Zach, I'll send you back to the slide.
Yeah, no problem at all. So the environmental community was semi-optimistic about this revised general permit, and they got some things in there initially that they were happy about. And what happened is, through that not the rulemaking, but the adoption process of the general permit, the Farm Bureau got its mitts in there and exerted its political influence, and the general permit ended up being diluted from what was originally contemplated in the draft. And so some of these improvements that were in this 2020 general permit include the requirement of quarterly instead of annual reports. So the 2015 annual report requires these CAFOs to produce 1 report a year. Now they have to do 4. Most regulated entities under permits to pollute have to produce monthly reports. So a quarterly cycle is an improvement, but it's not great still. Another thing that the general permit, as originally revised, targeted was this winter waste application. And as I said earlier, the CAFO operators like to land apply all of this waste that's produced in their CAFOs under the auspices of fertilizer. And of course, they're not growing anything in the winter. And when that happens, they dump all the waste out there. The ground is frozen. And then in spring, when it melts, just a tremendous influx of waste goes down into Michigan's waters through that tile system. And so originally there was going to be a flat prohibition all winter long, but the Farm Bureau and others got this narrowed down to a limitation from land applying in January through March. And the third thing that the CAFO operators didn't like is there's this tool called a manifest, where when you've put all the poop and pee that you possibly can on your land, you can put it on your neighbors through this tool called a manifest. And there's very, very loose record keeping requirements and informational requirements associated with this tool. And the 2020 revised permit was originally going to require much better measures. So the regulators were aware of how much waste was being manifested. But again, the approved, adopted general permit wasn't as good as folks had hoped, largely because of the Farm Bureau. Next slide.
Jack, if I may,
Sure.
You're certainly welcome to do the same when I'm presenting. One of the things that you should all be aware of is this manifest idea these are reporting forms for disposal of waste generally in Michigan. It's been the practice of Michigan for hazardous waste disposal and all solid waste disposal for really since the early 1980s to require manifest forms, and it's a way of tracking what is generated as waste and where it goes. It's as simple as that.
Thanks, Jim. There we go. Okay, so although the Farm Bureau managed to meddle its way to a much less protective 2020 general permit, it was not happy because of those foregoing problems from its perspective that I just flagged. So what did it do? First of all, it initiated a contested case in 2020 where it was challenging the permit in a variety of ways before an administrative law judge. It also, a couple of months after it filed that contested case, it filed a case in the Court of Claims seeking a declaratory judgment that Eagle exceeded its authority by promulgating this general permit without going through the process of adopting new regulations. And what happened in this Court of Claims case is that the Court of Claims said, hold on a second, we're not going to get to the merits of the issue because you have a case pending you have a contested case pending before the ALJ. We think that you have not exhausted your remedies, and so we're going to dismiss this matter for lack of subject matter jurisdiction. And the Farm Bureau, of course, didn't like that, so it appealed that decision to the Court of Appeals. And the Court of Appeals said, well, we think that the Court of Claims got it right, they just didn't get it quite right. And instead of the case not being exhausted because of the pendency of the contested case, we think you, Farm Bureau, should have filed a request for a declaratory ruling with Eagle before seeking a declaratory judgment. And because you didn't do that, you failed to exhaust your administrative remedies, and this case needs to be dismissed for lack of subject matter jurisdiction. But then, curiously, the Court of Appeals decided to opine on this matter of whether Eagle should have gone through the rulemaking process to enact this new 2020 general permit. And in its opinion, it said that's exactly what Eagle should have done. And of course, the people that were concerned about the 2020 general permit were very, very worried about this. And I forgot to mention that in the 2020 contested case, Flo, and I think I talk about this in the next slide now that I think about it, but Flo and a group of allies under the leadership of ELPC, the Environmental Law and Policy Center, which is based in Chicago and was lead counsel on that, they intervened in the contested case. And it was an interesting posture because whereas the Farm Bureau was challenging Eagle's 2020 general permit as being overly ambitious, overly requiring too much of CAFO operators, the environmental interveners felt just the opposite and felt like the 2020 general permit wasn't strong enough, and therefore they were contesting the fact that Eagle actually didn't do a good enough job in promulgating that 2020 general permit. So what happened then is the environmental plaintiffs in the contested case were worried that the Farm Bureau was going to come back to the contested case and say, hey, look what the Court of Appeals just said. It said that Eagle didn't have authority to enact this or to adopt this new general permit without going through the rulemaking process. And if that's what the Farm Bureau says, we're worried that the ALJ is going to agree with that and feel compelled to follow the Court of Appeals, what we call dicta in the legal profession, which is just its ruling on this issue of whether Eagle should have gone through rulemaking. And so the upshot of all this is that Eagle disagreed with the Court of Appeals ruling that it was required to go through rulemaking and sought leave for Supreme Court review. And the environmental plaintiffs in the contested case, and basically the result of that is that the contested case was stayed pending a decision from the Michigan Supreme Court. And Jim and I became involved in this amicus effort because the environmental plaintiffs had not participated in the matter before the Court of Claims and wanted to present arguments that were separate from Eagle's to the Supreme Court that explained why the Court of Appeals decision was going to be so harmful to Michigan's waters. And I also have on here that, and I'm sorry this is not easier to explain, but it's just kind of a complicated case. But one of the things that happened since that amicus brief was submitted is that the Farm Bureau actually submitted a request for a declaratory ruling to Eagle as to whether or not Eagle should have gone through rulemaking. That was denied, and now the Farm Bureau has filed a new case in the Court of Claims, which is seeking to have the Court of Claims rule that the rule that the general permit is invalid for lack of rulemaking on Eagle's behalf.
And
All right.
I'm just say to explain, even though this is the pathway of this case to the Supreme Court started with a contested case and then ended up the issues ended up being stayed because of what Zach explained with the Court of Claims in the first case and the Court of Appeals in the first case, and the dissatisfaction of Eagle and the dissatisfaction of the intervener groups, including Flow. So you have that, and that's the issue before the Supreme Court, everybody. What the CAFO industry did, and Farm Bureau did in this recent case, which was just filed last week, what they've done is they have fixed the problem. Zach said they didn't ask for a declaratory ruling. The Court of Appeals didn't really have jurisdiction to make the adverse ruling that it did. So what did Farm Bureau do? They're defending in the Supreme Court, and if they lose that, they've got another shot at it with the Court of Claims again, and they'll get back up to the Court of Appeals and try to get that decision reinstated. Either way, the issue in the Supreme Court is the controlling issue. Is it a rule? Is the general permit a rule? Thus, the conditions that we need added as a 2020 permit are not allowed because it wasn't promulgated, or is it a permit, in which case conditions can be added? And that's the central question. Zach, are you going to cover the Part 31 bar? I think you are, aren't you?
Yeah, I think that's in the next slide.
Okay.
So yeah, I already talked about this in association with the last slide. So Jim, you can go one more, I think. Yeah, so the really neat thing about the Farm Bureau's argument that Eagle can't update the general permit without going through rulemaking is that in 2004, 2005, the legislature passed a law as an amendment to Part 31 of NAREPA, which eliminated Eagle's rulemaking authority. And the upshot of this, of course, is if Eagle has to go through rulemaking to update the 2015 general permit, it can't. And if it can't do that, then this 2015 general permit, which everybody knows is unsatisfactory and leading to pollution and impairment of Michigan's waters, stays. So we're obviously very, very concerned about that. And one of the disadvantages of intervening in the contested case, but not the case before the Court of Claims, is the Court of Claims did not get to hear the concerns that we've raised with our allies in this amicus brief. And one of the things we do in that brief is we spell out that under Article 4, Section 52 of the Michigan Constitution, the legislature has a duty to protect Michigan's waters from pollution. And the primary law that they've enacted to do that is the Michigan Environmental Protection Act, or MEPA. And it basically just carries forward that duty into, among other things, agency action, so that an agency has an obligation to make sure that this constitutional guarantee, which is a paramount interest, you know, the only thing that's described as a paramount interest in Michigan's Constitution, so that the citizens of Michigan get to enjoy that right. And the Court of Appeals never considered any of these arguments. It never considered the fact that if, in fact, it was right that Eagle had to go through a rulemaking process to update the CAFO general permit, that it would then have this constitutional conflict, or at least a statutory conflict, whereby Eagle would have to issue these certificates under its 2015 general permit that it knew were not adequately protecting Michigan's water resources as required by the Constitution and MEPA. And I'm going to turn it over to Jim now, who will delve in a little bit more to these things I've just discussed, and take it away, Jim.
Yeah, that's just right, Zach. Thank you. So I'm going to start right where Zach left off, and that's the Michigan Constitution, MEPA, and the confounding position of Farm Bureau by arguing that an amendment to Part 31 back in 2005, effective in 2006, prohibits it. It froze the general permit, and then later froze the general permit in 2015. And by freezing it, Farm Bureau thinks that if this is a rule, there can't be any more rulemaking under the amendments in 2000 that became effective in 2006. It bars any new rulemaking. So if it's a rule, nothing can be done to protect Michigan's environment. And as Zach points out, that's contrary to the Michigan Constitution, the Environmental Protection Act, and frankly, the plain language of Part 31. So in effect, Farm Bureau is arguing before the courts of Michigan that the legislature insulated them and bound the state, notwithstanding its constitution and laws, to a general permit that allows them to pollute at the level that Zach has described in his presentation. That is how serious of a breach that we think is occurring here in this case. And as Zach explained, these are some of the contours of the arguments to the Supreme Court to try to put this case in the right context when you decide whether the arguments of Farm Bureau make any sense. Why would you let Farm Bureau argue it was a rule when that conclusion would violate what Zach just described? So that, I hope, leads into what I'm about to say. So I'm going to start by talking about the Michigan Constitution. The air, water, and natural resources are of paramount concern, as Zach said. The language of the Constitution said the legislature shall provide, that is, they shall enact laws to protect the environment, and the legislature has done so, including MEPA, including inland lakes and streams, Great Lakes Submerged Lands Act, Wetlands Protection Act, all of our waste laws, including Part 31 at issue in this case. The whole purpose of those laws was to protect the environment. The Michigan appellate courts have ruled that this provision is self-executing. What does that mean? That means the legislature is bound to pass laws to protect the environment. So one of the fundamental questions in this case is whether the legislature had the right to amend Part 31 to freeze the 2015 permit, and if it's a rule, to prohibit any conditions and any protection of the environment. So you can see what kind of conflict and contradictions that are in with the damages, the unbelievable magnitude of harm that is occurring in the state of Michigan and elsewhere. And it's not just Lake Erie; it's all of the lakes and streams that are hydrologically connected to these concentrated farms. So So one of the questions in the case is whether or not the Part 31 amendment that blocks rulemaking actually violates the Michigan Constitution, or as Zach said, at the very least, it violates the duty under the Michigan Environmental Protection Act that requires the state to prevent environmental contamination in the state of Michigan, according to a Supreme Court decision, and we'll go to that right now. So, well, here's MEPA. This is a citizen suit law. There's two aspects of MEPA. One is citizens have a right to go to court no matter what permits are issued, even if the permits are valid. They have an independent cause of action to contest whether or not the conduct that has been permitted is likely to pollute, impair, or destroy the air, water, natural resources, or the public trust. What do we mean by public trust? Just footnote: public trust when you have navigable waters and pollution coming into navigable waters, and you interfere with fishing, boating, drinking water, domestic water use, environmental quality. When you interfere with the environment through connected conduct to waterways like this, public trust is triggered. Independent of public trust, anytime there's pollution of any of the natural resources of the state, it violates the Michigan Environmental Protection Act, and citizens have a right anytime to invoke this. And this, as we'll talk about at the end here, this is one of the kind of remedies that citizens may have that would not get bound up in this ball of yarn that's happening in the Supreme Court and the Court of Claims, Court of Appeals. One of the very powerful things about this statute is that it also applies to an agency decision, like the general permit in this case. And as Zach said, not even the state and certainly the Court of Appeals considered the application of the Environmental Protection Act, and the Supreme Court has ruled consistently that the Environmental Protection Act applies to agency proceedings. And this section 1705 down here, whoops, excuse me, what did I do here? You'll see here 1705 down here near the bottom. That says a state agency must consider and determine whether there are likely effects in any approval process. So you have a general permit approval process leading to a certificate of compliance with the general permit, as Zach said. That was not done in this case. So there's a whole counterpoint here of illegality that Flo and LPEC and the interveners represented by the lawyers in the amicus brief are raising. Now, whether or not that gets decided by the Supreme Court, that may or may not happen, but it puts notice across the bow that these issues are in play, not only for Farm Bureau and the animal feed operations, but for Eagle itself, because this is a tool they should have used and didn't. And Zach and I have had long discussions about this when we first got involved in looking at this amicus brief and what went wrong and how did we get here.
I just wanted to add, Jim, if I could, that
yeah, please. Thank you.
I'm as B said at the outset, I'm kind of new to Michigan. I've only been here a couple of years, and I was just blown away by MEPA when I got here, because it's very unique to have a state law that runs parallel to the permitting process and is meant to inform the permitting process. So I mean, I would distill what this all says here in this slide down to the fact that if Eagle issues a permit without considering MEPA and the CAFOs follow those permit conditions to a T, we can potentially attack Eagle for not applying MEPA at the time of its decision of issuing that certificate of coverage, perhaps at the time of revising the permit. And we can also attack the CAFO operator who's operating in compliance with its permit terms, as long as its conduct results in pollution or impairment. So it's just a remarkable statute that is a great tool here in Michigan.
And substantively, what Zach is saying is, everybody, the power of this is that even if there's compliance with the permit standards, if there are other facts with compliance that are likely to pollute, impair, or destroy the air, water, and natural resources, the permit must be prohibited under the language of the statute here. unless, and here's the kicker, the applicant, or in a court case, if this were a citizen suit, because the standards are the same, the applicant must show that there are no feasible and prudent alternatives to the conduct authorized by the permit. And the fact is, once Farm Bureau or anybody in this state is polluting, if they have other alternatives that are either less polluting or non-polluting, they must take those alternatives. And it gets right to the point that Zach was saying at the beginning, and that first slide, there is treatment of human waste. There is no treatment of animal waste, and the animal waste is, Zach, I don't know what the magnitude is, but it's mind-boggling how much animal waste is going into our environment with absolutely no controls. And they call it fertilizer, when in fact there's so much phosphorus in the soil at this point over the last 20 years. As Keith Schneider and experts have pointed out, we don't need any more fertilizer for years. So this is where we find ourselves, and this statute becomes a very potent tool, we think, for other organizations, other people who are being harmed, even those in Cleveland and those enjoying Lake Erie, that there are lots of potential ways in which we should be demanding as citizens. This is a citizen suit law, and it's a law intended to include citizens in the agencies, so that they're not in, they're not like the, we just saw the Kentucky Derby, although I missed it, but they're not like a horse ready to race with the blinders on. We're only going to look at the permit. No, you can't do that anymore under this statute. So, as Zach said, Michigan Supreme Court in 1975, there's a duty on state and local governments to prevent and minimize environmental degradation. That's the duty Zach was mentioning under MIPA. And that you can't breach that. 1703, you can have a citizen suit, which I've already described. Under this Vanderklut case, every agency, including local governments, if they're involved in permitting, zoning, or issues related to these farms, local governments too have to consider the effects on the environment of the conduct that they're considering for approval. So we think MIPA applies to the general permit process. MIPA is supplemental, as we've said, and it must apply. We think that rulemaking is required to revise the permit, and the interference with that by blocking rulemaking by the legislature violates the constitutional duty, self-executing duty under Article 452. We also think that Part 31 rule that prohibits the agency, according to Farm Bureau, we don't agree with them, but according to Farm Bureau, the agency's stuck with the 2015 permit, and so are the rest of us. We think that the MIPA and the Constitution would void that rule. I'm looking at our time. It's 1:45. I don't think I need to get into more detail. I have a suggestion too, that for some of you that want to work on the local level, there are opportunities for local police power ordinances and working through your land use and zoning ordinance. That's a whole nother topic. So I'm not going to get into that. I'm going to end right here. And Zach, if you want to add something, fine, or we can turn it back to Kim, I guess.
No, I think that, Jim, thanks for all that. That's great information. And you have contact information for Flowdown. Actually, it's a website, but you can find all the contact information that you need on that website if you have any questions. And those local tools in terms of zoning and police powers can be really effective too in combating CAFO pollution. In Wisconsin, I know recently there's been some pretty good momentum on those fronts. So yeah, thanks for listening, and we're happy to take some questions. I think that there's a short announcement before then.
Yeah, I'm going to get out of this PowerPoint, and if you have questions about it later, we can put it up, but that way you can all see each other.
All right, well, I first, just on behalf of, I think, everyone here, want to thank you, Zach, and you, Jim, for this really informative and insightful and concerning presentation. I mean, you really provided us with such in-depth and important information about what's going on with CAFOs and water and Michigan's laws and how we can try to utilize what we have to try to protect our waterways. So thank you so much. And before we get into those questions, for anyone who joined us after the beginning, I want to thank you for having joined us. If you want to become a member to help support our work and continue having events like this that are of no cost for people to attend, the best way to support us is to become a member. So the membership page is in the chat. If you want to stay up to date on future events and presentations and all VegMichigan happenings, consider sign up for our monthly e-newsletter. So I've put that in the chat. Okay, so I see a question from Mike. There was no mention of MDARD yet. What is their position on the 2020 general permit?
I'm sorry, what is our position?
So he is asking, what is the MDARD's position on the 2020 general permit?
I'm not sure what MGuard's position is unknown. They have not taken a public position, not in the court proceedings. So that's all I can answer. Whether or not they've made decisions about some of these operations, I'm sure they have. But the issue here is the permit, and I'm not sure what. I didn't see anything in the record that they took a position one way or another. Did you, Zach? I don't think so. I'm sure their approval of the GAMP was in evidence, but that GAMP doesn't satisfy the general permit.
I don't know. Do you want to go through the chat and pick out the questions for us, or should we just answer the ones we see?
It's, I'm whatever is most comfortable for you. I do see another one came in. Feel free to answer that, Zach.
Yeah, Tom's question jumped out at me. So do we feel Eagle is dedicated as environmental organizations to protect Michigan's environment? I think that's a really tough question to answer. I think there are employees of Eagle who are lifers, who are super passionate and do the best they can, and we owe them a debt of gratitude. I also think there are political animals at Eagle who are doing what they need to do to advance. And I think at the top of Eagle, there's all kinds of political pressure that it's hard to even understand just how significant that pressure is. But I will tell you that the 2020 general permit is not as good as it could be because Eagle has given in to that political pressure. And it probably did that to avoid going to court, and it's in court anyway. So one of the hopes of having a MIPA lawsuit would be to force Eagle to go through the proper legal exercise before making decisions like this. So, but I know, having worked in Indian country for a long time, that in working with agencies, federal, state, they just face tremendous pressure, and you always wish that they would do better than they do.
Yeah, I would only add to that the reason the Environmental Protection Act, the MIPA, and these other laws were passed, but particularly MIPA, was to get at the inherent problem of governments, because of political influence, being forced to compromise their legal obligations. And in Michigan, anecdotally, I can tell you that, and I don't mean to get political, but I'm just going to state what I think is fact. After Governor Engler took office, there was an erosion of amendments to various environmental laws, and Michigan began to retreat. And one of the internal positions of the government, that even though what we've presented to you tonight, that Article 452 of the Constitution and the duties imposed by MIPA require agencies to do these findings to protect the broader interests of the state concerning the environment on every proceeding that approves conduct that could pollute. The administration took the position that MIPA didn't apply to any permit proceedings, even though the statute says so. And that has gone on in various ways, with lots of bouncing back and forth, or a pendulum, in various ways that has continued to this day. I think leaders now understand that's not the law, and I think the only thing that stands in the way now is for citizens to begin to exercise their rights under MIPA and bring us back to where we were before 1995.
Here's another question from B. What would a good result be if the court rules that the 2006 law removing Eagle's rulemaking ability? What's the practical effect of that? How long would it take to get a new rule promulgated? Is there another remedy you're asking for? You
Good
want to
question.
take that one, Jim, or want me to?
Well, I mean, I'll just say this. The rulemaking, if they have to amend the rule, it's a process defined by the Administrative Procedures Act. You have two things in the Administrative Procedures Act. You have the right to appeal permits, either in the courts or a contested case, like in this instance, and that's individual decisions. Rulemaking is a delegated authority from the legislature to basically exercise legislative authority. In order for agencies to do that, they go through a notice process, they go through a rulemaking process, they provide notice of the rules, there's a comment period, there's more amendments, there are revisions, there's more notice and comment, and it can go on for some time. And ultimately, it has to be approved by what's called JCAR. It's a legislative committee that puts their stamp of approval on it to make it a rule. Independent cause of action, we believe what we've presented tonight is the strategical direction for Michigan, for the people of Michigan and communities of Michigan to go to bring this within the law.
And then crystal balling this a little bit. The Supreme Court has an easy out if it wants to take it, which is that the Court of Appeals didn't have subject matter jurisdiction because the Farm Bureau failed to exhaust its administrative remedies, and therefore the Court of Appeals' thoughts on rulemaking are void. But since the Farm Bureau has already filed a new case before the Court of Claims, the Supreme Court's going to know that if it makes that ruling, the Court of Claims is going to face that issue as an issue of first impression, and the delay that's associated with that may inspire the Supreme Court, depending on its feelings, to decide the rulemaking issue or not. But from my experience in the courts, I would not be surprised if the Supreme Court dodges the question and allows it to sort of play out before the Court of Claims. The other thing I wanted to clarify is that if the Supreme Court should rule in Eagle's favor and say that Eagle's general permit did not have to go through rulemaking and is procedurally valid, that's all well and good, but that would take us back to the contested case where we're actually in an adversarial position to Eagle, and we're arguing that the 2020 permit isn't good enough. So this is an odd case, and that a victory before the Supreme Court just leads to a new battle against the party that we're aligned with before the Supreme Court. Hopefully that makes sense, but it's confusing.
Right. There's a question about whether or not the Right to Farm Act is a defense to the Michigan citizenship laws, and the answer is, to my knowledge, so far, no. MIPA is supplemental to other laws and is an independent cause of action. And there's nothing in MIPA that was amended when the Right to Farm Act was passed, and the Constitution bars amending a statute by implication through a law like the Right to Farm Act. What else? Oh, there's a question here and a comment, and a very interesting one. I think it was Angela I saw, if that's correct, ask a question about, is Michigan Constitution, she compared it to this movement across the country to create constitutional amendments, and really it's worldwide, about environment, water, natural resources being, having their own rights. In other words, a right to the environment and citizens, and then this question of right the rights of trees, metaphorically, or the rights of nature. There are, we don't have any rights of nature amendments yet, but we have several states that are adopting citizen rights in the environment. And Michigan, yes, did this in 1963 with incredible vision on the part of the convention, the CONCON. And I will say that it took MIPA to do it, but the author of that at University of Michigan, Joe Sachs, who has passed away, who won a Blue Planet Prize for this drafting this statute because of its empowerment of citizens and government, I would say, that Michigan does have, citizens of Michigan do have a right through the Michigan Environmental Protection Act.
Val, I was gonna say real quick, I saw your question about when is the Supreme Court gonna make a decision? We don't know. The briefing was done in the middle of February, if I'm remembering correctly, and so it's not clear when the Supreme Court's gonna make a decision.
Yeah. Yeah, there's two questions now. One is the Ohio rights in nature, or the rights of Lake Erie. That was not a state law. That was an effort, a political effort, which was successful to get it passed. Toledo passed basically a rights in nature or rights of Lake Erie ordinance. But the court struck it down as unfounded because only the state of Ohio, not local governments, can create a statute which binds the state and binds the farming industry. So I think it's extremely valuable, rights in nature, because it educates us about the fact that that humans and nature are one, as many of the great conservationists throughout history have reminded us. But it has not gained traction yet. What has gained traction is that we do have rights as citizens to bring lawsuits on behalf of the environment under MIPA. Even though we bring it on behalf of ourselves and others, the way the MIPA is structured, it does, in a sense, ends up with the same result as a rights in nature statute would have.
Say real quickly too that there is some progress being made in rights of nature in Indian laws. So tribes are adopting those, and their courts have different standing laws, and tribes are just generally more amenable to the philosophical underpinning of that. So hopefully some really strong laws will emerge in Indian country and help to inform the adoption of those in the states.
Yeah, what rights in nature does, and again, that can happen by constitutional amendment in any of the states in the U.S. I doubt it could by U.S. Because the U.S. can't create those kinds of rights, because generally the states have jurisdiction over natural resources, at least to that extent. But what's really interesting about rights to nature is that you still have to bring a lawsuit to protect them. But what happens is there's a subtle change, because typically under the way the law is now, you have to worry about what you do to human beings and their use of the environment. But you don't have to, but you don't have to worry about what you do to the environment, because the environment can't sue you. Lake Erie can't sue. If Lake Erie could sue, then arguably anybody would be responsible for both damaging the rights of Lake Erie and damaging the rights of the people that use Lake Erie. So you have two things. And I think as a practical matter, and it's a good result, is that it requires, in a sense, a respect for nature embedded in law. But remember, no matter what happens, it still takes hands, feet, mouths, writing, financial resources, human dedication to enforce the rights of nature, because nature isn't going to enforce those rights. So it still brings us back to the fundamental responsibility that citizens have to insist that these are implemented.
this is a good tie-in to the question that Mike asks about, is the right to farm a legal right to pollute? And the rights of nature, well, let me start off by saying this. All environmental laws are inappropriately cast by the regulated community as being onerous and, bad for business and all that crap. What the Clean Water Act, what the Clean Air Act, what all these environmental statutes do is they actually are entitlements to pollute. It's just the opposite. Like if we had rights of nature as the fundamental underpinnings of our legal system, then there would be no right to pollute whatsoever. But what all of these permits do is they operate by saying, what is an acceptable amount of pollution and then allocating that across all of these polluting industries. And one of the things that Flow does is we work with the public trust doctrine because it's an alternative to this regulatory system that is all about the right to pollute. And sure, it does limit the amount of pollution that entities can spew into our waters and air, but the cost of that, Jim, we see this in the evolution of figuring out just how awful some of these contaminants are over time, where we didn't have the knowledge at the outset, but you learn that what was permitted was actually quite dangerous, or is actually bioconcentrating in fish and making its way into human bodies, or is getting into the placenta of inside the womb, and so yes, the right to farm law is a legal right to pollute. All of the, a CAFO permit is a legal right to pollute. And that's why we have to do the best that we can by using MIPA and the public trust doctrine and these other tools to try to minimize that right as much as possible.
Yeah, I would urge everybody, if you're or anyone on this call, and to go to our website and educate yourselves about the public trust doctrine. It probably is the most common, the most profound and applicable common law right that citizens have to deal with the issues we're facing in the 21st century. I don't think I'm exaggerating. Fortunately, in Michigan, we have the Michigan Environmental Protection Act, which is not a law that allows to pollute because it isn't a regulation. It creates duties and responsibilities to not pollute. So in Michigan, we have the tools that we need, but we need organizations like yours, like Flow, all the organizations in Michigan and beyond that, because this is, I grew up in the environmental movement as an environmental lawyer because that's what I wanted to do. I discovered that later, but that's what I wanted to do when I was 27 years old. And we're at a point now, Zach implied, or maybe he said, the Earth systems, we have systemic threats because of these laws that have tried to protect the environment. Because they allow some pollution, it's accumulated to the point where the systemic threats need a response. And statutes like MIPA and the public trust doctrine, which I urge you to look at, which says that you are each a beneficiary of all and have rights of fishing, boating, swimming, recreation, sanitation, drinking water in all the waters in the state of Michigan, and every state has that same common law trust. And those waters can't be impaired from one generation to the next by government or private industry. And we need to exercise that basic right. It's so profound that it actually limits the right of private property. So it's not subject to a takings clause argument, where if the state went too far and Farm Bureau said, and they have said in the new 2023 Court of Claims case, well, these regulations in the 2020 permit, if you're going to apply these standards, they take our private property rights to farm, which they're saying they take our right to put all this crap on the ground and ruin Lake Erie and our lakes and streams. But that's what they're saying. The public trust would defeat that. So underneath right to nature is this whole question of the world's commons, which we all live on, and then the right of private property. And what we're really talking about is a tension between an overstated entitlement of private property that has cast a shadow, if not an eclipse, on the commons, which even private property depends upon, but all of us depend upon. And I think the public trust doctrine and the rights of nature have a role to play here to rebalance this tension.
Well, I just want to say again, Zach and Jim, thank you so much. Thanks for the work that you do at Flow. For anyone who wants to learn more, I did put a link to Flow for the loveofwater.org in the chat. Thanks to everyone for these questions and for the thoughtful conversation. And I just really appreciate what you talked about, that, there are permits that give the right to pollute, but we have some tools that we can try to use to leverage, protecting our, environment as much as we can, which we need to do for people and for other species. So just, thank you again for sharing that. There are these conflicts, and what we can do the best that we can to leverage within those conflicts, creating a healthier, more compassionate, more rejuvenated world, a more equitable world for everyone. So I really appreciate you all. We are at the end of the hour. I just wanted to ask Zach or Jim if either of you have contact information that you want to put in the chat before we close. So if anyone does have additional questions or comments, that maybe they can contact you, or if it's best just to go to fortheloveofwater.org, and if that's how they can get a hold of you.
I will throw my email in here right now, and anyone is free to contact me.
All right, thank you so much. So I'm going to let them put their contact in. There you go. So Zach at flowforwater.org. Thank you
You
so
can
much.
find Jim at the same suffix. He's just Jim.
That's right.
Thank you. So Jim, Zach at flowforwater.org and Jim at flowforwater.org. Thank you both so much again. And thank you all for coming out this evening.